Welcome everyone. Thank you for joining us for another session in our Research Methods Explainer series. This series by the Kashf Initiative breaks down research approaches and methods accessible ways in clear and accessible ways for students and early career researchers. Today's session is titled as Understanding Legal Methods in Research. And here's how we'll navigate through the session. First, there will be our panelists will be speaking for 40 to 50 minutes, and then there will be a Q&A session. So before we begin, let me introduce Kashf to anyone new with us today. We are a non-profit initiative of researchers from South Asia based at different universities like Oxford, Cambridge, Edinburgh, JNU, DU, among others, dedicated to making research and learning in social sciences and humanities more accessible, especially for learners in non-metro regions or underserved institutions. Now that we look on how far we've come since the launch last year, we realize that at Kashf, our work began with a simple observation that some of the most fundamental skills in humanities and social sciences, like how to read a text closely, think methodologically, or ask sharp questions, are often sidelined in our pedagogy. Many of us have felt this gap firsthand. Kashf is our small but deliberate response to this. It's a space for pause, for returning to the fundamentals, not as a remedial step, but as a way of honoring the labor of thought. A reminder that scholarship can still be slow, generous, meaningful, and serious. We've hosted free, informative, and training sessions, sometimes multiple in a month, covering everything from the basics of research to writing a proposal to doing literature review to learning referencing. We have also hosted writing workshops and even special sessions co-hosted with seminar forums in Oxford and other institutions. To reach more learners, we have started offering sessions in regional languages as well. There's much more to come, and your input shapes it. If you think of a session topic or collaboration, do let us know. And now I would like to introduce you all to our panelist. So we have with us Dr. Srijan Sandip Mandal, and it's my pleasure to introduce Srijan to all of you. He's an assistant professor at NALSAR University of Law, Hyderabad, specializing in legal history, philosophy of history, and public history. He completed his MA, MPhil, and PhD in history from University of Hyderabad, where he was awarded the Andhra Bank Medal for securing first rank in his MA, and Dr. Sheila Raj Memorial Medal for the best PhD thesis in history. His research explores the intersections of law, history, and epistemology, with his MPhil examining the historiography of Tipu Sultan through a Kantian framework, and his PhD analyzing how constitutional restrictions on free speech in India preserved colonial legal studies. He has also developed a strong engagement with public history and currently serves as secretary of the International Federation for Public History. And Dr. Mandal has presented his work at leading academic institutions in India and internationally, and is presently working on a book manuscript based on his research in legal history. Beyond academia, he actively contributes to public discourse through publications, digital initiatives, and heritage engagements, making his scholarship accessible to wider audience. We welcome you here, sir, and it has been an honor to have you here. Now I would like to hand over the session to sir without much ado. Thank you so much. You can carry forward the discussion.
Thank you so much, Akansha, for so warmly introducing me. And thank you to Kashf for having me here to do a methods talk, which, as I was telling Vidushi and Akansha, is the first time I'm doing it. So let's see how it goes. And you were absolutely right when you introduced the initiative that these things are never taught to us. And this is something that even when I was a research scholar and I was a student, I was also wondering that shouldn't somebody be teaching us these things rather than us figuring it out by looking at our seniors' theses and either adopting the best or the worst practices depending on which thesis we end up picking up from the library. So this is a great initiative, and thank you for making me part of it. So, okay. Now, as you guys know that in today's talk, the idea is for me to try to introduce to you what legal research looks like and what different sorts of legal methods look like. So just a little bit of clarification. So when you use the word legal methods, we are, of course, using it in the context of doing research on something that is connected with the law. Now, if you were a student of law, legal methods would be the very first course that you would do in the first year of your BA LLB program. Because actually a basic introduction to law where there is very little method that actually happens. It's basically telling you very basics of the law, which may not be relevant to those of us who are, say, approaching the law not from the disciplinary standpoint of the law, or are not necessarily practicing law or aspiring to practice the law. So, assuming that we are trying to use the law in research, let's look at first what is law in the context of research. I would say that broadly you can think of the law when you use the law in a research framework, no matter what your discipline, into two things. One is statute and the other is case law. Okay. So, what is statute? Statute is, for example, the Bharatiya Nyaya Sanhita, which you may have heard of, referred to, which is effectively the plagiarized version of the Indian Penal Code. But of course, the government has called it something else, so let's call it that. Now, the Bharatiya Nyaya Sanhita is the example of a statute. That is to say that a legislature, in this case, the Parliament of India, passed it as an act of parliament, and therefore it is law. So, statute is one level of law. Below statute or below an act of parliament or an act of the state legislature is something called rules. So, for you to say bring into effect any law, you have to publish a set of rules. This will not apply to say something like the Bharatiya Nyaya Sanhita, because there is a comparative law, which is the version of the Code of Criminal Procedure or the Bharatiya Nagrik. I can't pronounce the name, so forget it. Basically, it's the Code of Criminal Procedure, right? So it won't apply for there, but say think of something like the Information Technology Act of 2000. The Information Technology Act of 2000 actually has a set of rules that allows you to bring that law into effect and actually make it work. So statute, one part of what constitutes law is statute. This also, if you stretch the definition of it a little bit, can also include the Constitution, because the Constitution is also a statute. It's just a supra statute for which there is a unique body that's created, which has a singular function, which is to create the Constitution. In India's case, it was the Constituent Assembly of India. And then that body ceases to exist. And it became, in India's case, the Provisional Parliament of India. So statute broadly is anything that a legislature passes which has the function of law or which works as law, by which you have to either in some ways modify your conduct. That's statute. Another part of law, which is the less familiar part of law, especially for people outside the field of law, is what is called case law. So what is case law? Case law effectively refers to a body of judgments which is interpreting a statute. So say I gave you the example of BNS. Okay? So if I'm giving you the example of BNS, there might be a lot of cases that emerge from it. Most of those cases will be cases where, say, someone is prosecuted under the Bharatiya Nyaya Sanhita for some crime or another, say murder, for instance, and that's it. So that is usually not something that would be considered case law until and unless a legal principle emerges about interpretation. So how does a legal principle usually emerge? Or how does case law actually emerge? Case law emerges when any case, goes to the level of the High Court or the Supreme Court. So these are constitutional courts. By constitutional courts, what I mean is that these are courts that have been mentioned by name and have chapters dedicated to them in the Constitution of India. So all the high courts of India are covered by the Constitution of India. The Supreme Court of India is covered by the Constitution of India. And they have many privileges and powers as a result of it. And they have a monopoly on interpreting the law. That is to say, how the law would be applied. So I'll give you a concrete example of this. Of course, nowadays one touts the fact that the crime sedition is not included in the Bharatiya Nyaya Sanhita. That's not quite accurate. There is a version of sedition that exists in section 152, but I will not go into that. So sedition used to exist in the erstwhile Indian Penal Code. There was a person in Bihar in the 1950s named Kedarnath Singh, he was arrested for speeches that he had made against the then Congress government, the Indian National Congress. And he was a member of a version of a left-wing party, not the Communist Party of India, but one of the smaller left-wing parties. Now, he was convicted of sedition by a lower court. He challenged that conviction at a higher court. That higher court sustained his conviction. That is to say, that higher court said that the lower court was right in convicting him of sedition. So that is how usually criminal law would work. But when he took the matter to the Supreme Court, he did something else. He challenged the constitutionality of sedition itself. What does it mean, constitutionality of sedition? Meaning that he said that sedition violates the right to freedom of speech and expression that is available to citizens from the 26th of January 1950. And the Supreme Court had to determine whether or not it actually violated the Constitution or not. They determined that it did not. There's a reason why they did it, but that's not relevant here. The fact that that judgment constitutes case law, and judgments like that constitute case law. Now, all judgments of the High Court or the Supreme Court do not deal with the constitutionality of any law. They can also deal with certain matters that emerge in the law when cases go up to constitutional courts. So in that case, for instance, what had happened was the Supreme Court, what is known as, read down the law. Reading down the law would be to effectively narrow the scope of the law beyond what the statute is actually saying. So if you read the statute, which is erstwhile section 124A of the Indian Penal Code, it is about disaffection. If you foment disaffection or attempt to foment disaffection against the government or the state, you are liable to be prosecuted for sedition. Disaffection is a very broad term. It can mean anything and everything. Any criticism can also make one subject to disaffection, which was the case with Kedarnath, the person, not the case itself. Now, in that case, what the Supreme Court did is that they read down the law by saying that disaffection will not be the criteria for determining who is prosecuted for sedition. You have to demonstrate that the words spoken have some relationship with an incident of public disorder. You need to create a proximate connection. That means there has to be not necessarily a causal link, but certainly a contextual link. Only then does it become a crime under sedition. Which means that what the Supreme Court did was they reduced the scope of the law from what the words of the statute actually say. And that's what case law does. Case law allows and adds a lot of meaning to the words that one usually finds in statutes. So if you are looking at law only through statute, you have a partial view of the law. Your view of the law is only becomes textually complete. I'm saying textually complete because the law in practice is the actual law. How it's experienced by people is the actual law. This is textual. And the law as practiced is very different from the law in theory. But for the purposes of research, this is the distinction that I want to make, is that so your statute is incomplete without case law. And it is only when you combine the statute with case law do you get the totality, or at least the textual totality of what law is. So this is the subject of law. So what the discipline of law does usually at the research level and even at the training level is that it introduces students to both statute and case law by teaching them about different cases or what they consider landmark cases. There is no objective criteria for a landmark case. A landmark case is effectively a group of people over the years considering a case very important, citing it a lot in future cases, and so on and so forth. So for the purposes of whenever you're using the term research methods for the study of law, or even legal methods, although I would say legal research is probably a more accurate term because legal methods has that implication of the first year BLLB law course. So that is what you're talking about in terms of law. Now, how is it that students of law, or at least researchers or scholars of law, study the law? And how is it that other folks, say somebody like me who comes to law from history, how are they studying? So what scholars of law usually do, and not all of them, but the dominant method of approaching the law in the discipline of law is what's known as the doctrinal method. So what's the doctrinal method? Doctrine refers to effectively a body of case law. What I said was case law. Case law are judgments relevant to a case or a statute that is emerging from the Supreme Court or from the High Court. So when you take a set of cases, say if you're taking a set of cases around sedition and what the Supreme Court considers sedition and what it doesn't. And I gave you an example of how after 1963 is 62, when Kedarnath Singh versus the state of Bihar, that judgment was issued, sedition scope in the Supreme Court's mind was narrow. Until that time, from 1870, when sedition had first come, the scope was much wider, which is what, say, Lokmanya Tilak or Bal Gangadhar Tilak, Mohandas Karamchand Gandhi, and many other nationalist leaders underwent. That was a different version of sedition. This was a different version of sedition, a narrower version of sedition, despite the fact that the words had not changed, because case law had narrowed the scope. So what's happening is that doctrinal method effectively refers to you taking a set of cases about any law and trying to figure out or impose order over it. That imposing order is considered doctrine. Now, ideally, how they would present it to you is that they are trying to delineate or detect or discern a pattern from, if you look at a number of cases, say you're looking at 10 cases or 20 cases, you will see a pattern in the judgments, and pattern that you will see is in the reasoning of a judgment. And that pattern is then in some ways, theorized would be a strong word, but it is given a shape of almost like a rule, which is not really there in the statute, but which aids judges. And that effectively is doctrine. I'm simplifying it here. I might even be stereotyping it here. And maybe there are legal scholars who would disagree with me. But broadly, that is what I would consider doctrine. And the doctrinal research method or the doctrinal method in law is principally about this. Because there is such a vast array of statutes and case law that's available, you can take any subject of law, you can look at the statute, you can look at the rules if they are applicable, and you can look at the case law that has emerged. You can select cases that you consider landmark or you consider important or consequential, and then from there you can try to arrive at a doctrine. So that's the doctrinal method. Another thing to remember in the doctrinal method is that what happens in judgments is that judgments and the way judgments are used in law, there are three pretentious terms to remember. I call them pretentious because they are in Latin. One doesn't have to use Latin, but in the field of law, people are obsessed with Latin because we have basically inherited the common law tradition from England. So one principle is there of stare decisis. Stare decisis is just a very fancy way of saying the rule of precedent. Basically, the idea is that when judges are arriving at judgments, they have to follow what earlier judges have done. They are required to follow it, which is why the earlier judgments act as precedent. They are not necessarily completely unable to go beyond the precedent. They can, but it's a very tricky thing to do. It's a relatively rare thing to do. They usually try to build on precedent. And that is why the idea is that case law is actually cumulative in theory, because you are building on existing precedent, existing precedent, existing precedent. And through this cumulative building, you're creating some kind of. So, which is why in the doctrinal method, the principle of stare decisis is so useful. Because judges are required to follow precedent, it follows that for a researcher to also look at a set of cases makes a lot of sense, because that's what judges are also looking at. So it actually is helpful both in terms of research and in terms of application in a court. That is one principle. Then there are two other words. One is called obiter dicta and ratio decidendi. Again, pretentious terms. You don't need to remember these Latin terms ever. But ratio decidendi effectively refers to the reasoning of a judgment. I'll give you a concrete example of this. You've all heard of the Ayodhya judgment. The Ayodhya judgment came in 2019. It is a 1045-page judgment. 1045 pages of it is not relevant to the actual finding. What is relevant to the actual finding is the last bit of it, which is about even that is, I would say, nearly 45 pages. I might be wrong about the number, but it is a fraction of the full judgment. Because what happens in judgments, if you ever read a judgment and don't doze off, basically you're given a lot of background, what one side said, what the other side said, what precedent was there, and they don't believe in quoting sparsely. They will quote paragraphs on end. So there is just, and they also use big fonts. So that, and they also use a lot of line spacing. So judgments tend to be quite long. But the germane part of the judgment, where the reasoning of the judgment actually resides, is known as ratio decidendi, which allows you to identify the legal principle or the legal reasoning that has allowed them to come to the conclusion that they have. So again, just as the principle of stare decisis is very helpful for the doctrinal method, similarly, the ratio decidendi is also very important, because the ratio decidendi allows the researcher to locate, and you can be a law researcher or any researcher, always go to the end of the judgment. Effectively, the last section and the penultimate section is where the reasoning lies. So that allows you to identify what is it that I should actually be reading if I want to get a sense of the reason. For other things, you can look at other sections. So ratio decidendi as a principle also helps in legal research, whether you're a law scholar or not a law scholar. And the third is this term called obiter dicta. Obiter dicta refers to what are known as incidental remarks. They might be reasoning X, but in doing so, they might say something else. They might give a remark that might act as precedent for a future judgment. So there is a judgment called in the 1990s, which declared that a mosque is not essential to the religion of Islam. So that this was a Supreme Court judgment that said that a mosque is not essential to the religion of Islam, which actually has a lot of role to play in the Babri Masjid judgment. But again, that's not the point of this. But the case was not about that. The case was actually a challenge to a law that the government of India had passed to acquire land in Ayodhya, including the disputed land. The case was challenging provisions of that. The question in the case was not on whether a mosque is essential to the practice of Islam. The judges ended up making it that. And it is a rather common phenomenon in law that judges will end up going into very deep exegesis or very deep, effectively, directions that are not relevant to the case at hand. Like the Babri Masjid judgment that I told you, it has an annexure that goes into the birth of Ram, the historicity of Ram, which is not the point of the case. The case is a title dispute. It's about property. It has nothing to do with that. But they made it about that. And that's very common. You will see that in many judgments that this starts to happen. Right? But again, coming back to research. So how is it useful? Because sometimes this obiter dicta might give you some clues to something. It might help you answer some research question that you have. And this is also a way for you to divide judgments. Ratio decidendi, obiter dicta, the reasoning and other incidental remarks, and the principle of stare decisis, which ensures that one judgment follows the other, has to build on the earlier one, and has to build on the earlier, and so on and so forth. There is also the problem, of course, building on things is that what the original judgment was supposed to say about a law, that completely becomes very different by the time you go 50 years later and 5 judgments later. But again, those are things that are not necessarily relevant to you if that is not your research question. That's your research question, of course. That's a fun thing to research as well. So that's usually what a legal researcher is doing. They are looking at this body of case law, and they tend to focus more on case law. The doctrinal method is not that obsessed with statute. It's mostly obsessed with case law, because case law is where reasoning resides. In the statute itself, there's rarely any reason. At best, what happens in, say, in Indian statutes, there's something called statement of objects and reasons at the start of every act of parliament, which gives the government's official version of why they're bringing in the law. And then, of course, there are the speeches that are made in parliament or in any state legislature in which the minister concerned or the parliamentarian concerned is introducing the law. But again, in doctrinal research, one very rarely looks at what happens in parliament. That is not a function of that. You are focused mostly on case law. At the most, you will go to statute. Even beyond that, if you're going to go, you will still stay within the text of the statute, which is where your statement of objects and reasons is. That's what they do. So therefore, the question that they are asking of case law or judgments is very different from the question that you will ask if you're from a different discipline. So for example, if you're a legal researcher doing doctrinal research, the question you're asking is, what is the legal principle that I can derive or legal reasoning that I can derive from this judgment when read in conjunction with other 10 judgments about this particular law? That is the principal question that they are addressing. Now, that is usually very different from the question that you will address if you are coming to the law from a different discipline. So I will take my example since I do history and I know history best. So I do legal history. That is not a question I will ever ask of a judgment because that's not even a historical question. A historical question of a judgment would be, why does the judgment read like this? So say if I were talking about 1962 Kedarnath Singh versus the state of Bihar, I will ask, why is it that in 1962 the Supreme Court decided that the law of sedition has to be protected, but it has to be read down? Or if I'm looking at the Babri Masjid judgment in 2019, I will ask, why is it that the Supreme Court decided to anonymously and unanimously give the site of the disputed Babri Masjid to the Ram Temple? The anonymous is a very important thing because judgments are rarely, if ever, anonymous. But this was unique. And anonymous and unanimous is even rarer. Right? So that is not a question. The why question that I'm asking is not a question of the doctrinal method. It's not a relevant question of the doctrinal method at all. But it is relevant to a historian. Anyone who's doing history, and this is also true of other disciplines, but anything that's in the past, and if you ask why does something exist in the form that it does, the answer to that question inevitably requires you to do historical research. Because if something exists 50 years in the past, and if you're trying to ask why does it exist in that form, you will have to try to look at the context, you will have to try to look at other documents around it to make sense of the document that you're trying to study. And in doing so, what you're ending up doing is a version of history. I'm not saying that other disciplines don't do it. They also do the same. It's just that for me, at least, if I have to distill the historical method in the question that we're asking, it's usually a why question about some phenomenon in the past, and that leads you to there. An additional thing that in, say, legal history, that at least I do, and I have seen other mostly scholars do in legal history, is that because we are not obsessed only with case law, we will go to the statute as well and try to ask the question, why does the law read like that? And what is it about this particular time and place that this particular version of the law came? Because that, of course, is a question that cannot be answered by just looking at the text of the law. Just like that question cannot be answered just by looking at the text of the judgment. You have to go beyond it. As soon as you're going beyond it, in textually also, you are doing something, I would say, different and distinct from what the doctrinal method. And if anything is historical, then what you're doing is a version of legal history. So, for example, if you look at, so there is a person named H.M. Sirvai. Okay, H.M. Sirvai is considered one of the greatest constitutional lawyers ever to have lived in India. He has a textbook. It's not a textbook, it's a commentary. It's a 3-volume commentary on the Constitution of India. It's called the Constitutional Law of India, a commentary, a critical commentary. I highly recommend it for anyone, even if you're not interested in the law, or if you want to just get a nice laugh. The way he has written it, you will start laughing at the derision with which he treats Supreme Court judges. That these people don't even know the law, they can't read the law and all of that. But he uses it in language. It's breathtaking in its dismissal of Supreme Court judges, which may seem impossible today, given how sensitive they are. But H.M. Sirvai, no judge had had the daring to say anything to him. He was that grand in the field, right? So, but what you will see when you read H.M. Sirvai is that he is interested in trying to derive legal principles. He is not going into the why and wherefores of why the Constitution reads the way it does or why the Constitution was passed in the form that he's not interested in at all. But if you say compare him with another person whose name is Granville Austin, who famously wrote a book in 1966 called The Indian Constitution, Cornerstone of a Nation, which was published by Oxford University Press in 1960. It was published by Clarendon Press of the Oxford University. He was a political science PhD scholar at the University of Oxford who decided to look at the making of the Indian Constitution. So he was a political science student. But what he was doing was effectively history. And it is regarded as the seminal work in the study of constitutional history. And it has been cited so many times by the Supreme Court that it is almost sacred in its importance. Now, if you look at Austin's work, what you will find is that Austin's work is interested in trying to answer the question that I mentioned. Why does the Constitution read the way that it does? And therefore, what he does is that he goes beyond the constitutional text. He looks at the proceedings of the Constituent Assembly debates to begin with. He goes further than that, looks at minutes of meetings and proceedings of meetings that took place in every committee and subcommittee of the Constituent Assembly. He goes deeper than that. He does interviews with many members of the Constituent Assembly because he did his research in the early 1960s. And in the early 1960s, many of them were alive, including Rajendra Prasad, who was the president of the Constituent Assembly and who gave him unfettered access to his private papers. As researchers, you know that research is also about the politics of access. So it is something to think about that an American researcher working at the University of Oxford was able to get unfettered access to the private papers of the former president of India. That is not an easy thing to swing. And anyone who does legal history will tell you that many of their ambitious projects come to naught because they cannot get access, right? Because access is a privilege, right? And Austin was incredibly privileged. So, but great scholar, worth reading, highly recommended book. So he's going through the assembly debates, from the assembly debates to the minutes of meetings, of proceedings, of meetings of different committees. He's going to also outside the Constituent Assembly to look at newspaper reports. He's also doing oral histories. And that is how he's creating his account, because his question is fundamentally different. And therefore, his approach is fundamentally different. I'll give you a couple of more examples. So, and more modern, more contemporary examples. Both Sirvai and Austin had written it a long time ago. You may have heard the name of Gautam Bhatia. He is a renowned legal scholar and a practicing lawyer at the Delhi High Court. He holds a PhD from the University of Oxford. He was from National Law School of India University, went to Yale. Impeccable credentials, okay? So one of the first books that Bhatia wrote was a book called Offend, Shock or Disturb, Free Speech in the Indian Constitution. I mentioned this because the book was published a few months before I submitted my thesis. And my thesis was on the history of the freedom of speech and expression, specifically on the restrictions on it. So at the University of Hyderabad in 2016. So when my doctoral advisory committee member told me that, hey, there is this book that came out, I was shit scared. I was like, please don't tell me that he's already made the argument that I have to make. Then what am I going to do with my thesis I'm supposed to submit now? Luckily, he wasn't. And that's where I also discovered the difference between historical research and legal research. Because Bhatia primarily takes a doctrinal approach, he is more interested in looking at the different grounds of restricting free speech, such as public order, sovereignty and integrity of India, for friendly relations with foreign states, defamation, contempt of court. There are about 8 such. And his chapters were organized around that. And what he did was, for each chapter, he was looking at the case law, that is to say, a set of cases that are about the freedom of speech and expression in India, around this particular restriction on the freedom of speech and expression, and trying to arrive at some doctrine, finding that there was not much of a doctrine, criticizing that doctrine, and suggesting an alternative way of reading the Constitution for judges. and for legal scholars as well. Like a more consistent, more philosophically informed reading, because he was doing the doctrinal method, right? So therefore, the book, the way that he sectioned the book is also around the different restrictions on the right to freedom of speech and expression. They are not around chronology at all. He has written a book like that also, which is The Transformative Constitution, which is a later book, but the first book is Offend, Shock, or Disturb. If you contrast that with the work of a legal historian who's probably the most renowned legal historian of India in the world, Rohit De, who's also trained as a lawyer. So like Bhatia, Rohit De also went to the National Law School of India University. He held a BLLB from there. Then he went to Yale. Then he went to Princeton to do a PhD in history, now teaches at Yale. His first book, which is his PhD thesis, is called A People's Constitution, The Everyday Life of the Law in the Indian Republic. That book is interesting to illustrate for you the difference between, say, the doctrinal approach and taking a historical approach to case law. If you open that book, what you will find is that every single chapter of that book is organized around one case. He's not going through multiple cases. He's just going through primarily one case. He's telling the story of one case. But the story that he's telling has nothing to do with the legal principle, which is a marginal part of the chapter, because you have to talk about the legal principle and the legal reasoning if you have to explain the judgment. But it's a marginal part of it, the legal principle of the legal reasoning. Most of it is about the circumstances of the litigation, the history of that litigation, the history of that issue that produced the litigation. So, for example, he has a chapter which is on a case called Muhammad Hanif Qureshi versus the state of Bihar. Muhammad Hanif Qureshi versus the state of Bihar is a case about cow slaughter. And the case is effectively challenging a Bihar law, and there were a number of such laws which were about bans on cow slaughter. One of the bans had come in Bihar, and this case went to the Supreme Court. There were a number of other cases also. And the Supreme Court upheld the ban on cow slaughter, which is why we have cow slaughter laws in India today. Because that was the first case where the cow slaughter law was challenged, and it was unsuccessfully challenged. So, one of the reasons why his approach, I would say, in some ways is richer, given that what he's trying to do, is that he's not just interested in the reasoning, like I said. What he's focused on are the petitioners. So one of the first things that he points to is that there were 3,000 petitioners in that case. So he says that it was one of the first examples of a class action lawsuit in India. And he said that all 3,000 were from the same caste of Qureshis. And the reason why he's pointing that out is he's saying this particular case was not about religion or the freedom of religion. This case was about caste and occupations associated with caste and the ability of a caste group like Qureshis, who were historically a butcher caste, to be able to practice their profession, which included butchering cows. That was part of their profession, and it was derived from their caste identity. So if you were taking a doctrinal approach, this is not something that's relevant to you. This is not relevant to the legal principle. It's not relevant to the legal reasoning. But because he's taking a historical approach, he's trying to find out who are these ordinary individuals who are taking on the state of Bihar in the Supreme Court of India against their law. These are not very wealthy folks. These are butchers by profession. So not many of them are very wealthy, but they're still doing it. Why are they doing it? Because they are trying to protect their livelihood. It's a livelihood issue for them. It's not the right to freedom of religion. The right to freedom of religion in the Indian Constitution is in Article 25. Right to livelihood is in Article 19. It's a different fundamental right. He's able to do that because of the question that he's asking is different. The sources that he's using is different. Again, since I began with the politics of access, Rohit De is unique in having access, one of the first scholars, as his own preface tells us, in accessing the Supreme Court archives. So the Supreme Court does not have an archive. Okay. What the Supreme Court has are basically, so the judgment is what the Supreme Court issues. But for them to issue the judgment, there are two sides or multiple parties. All of them have submitted petitions. All of them have submitted documents, right? very rich documents which lays out their case, provides a lot of details and evidence and everything. These things are never published. What is published for the general public and for interested scholars is only the text of the judgment. But all of these documents exist somewhere. So they exist in the Supreme Court records. Now that is not open to the public. How does one access that? Remember what I said, Rohit De is a student of law. So he studied at the National Law School of India University. And as part of his, he also clerked for, after graduating, the Chief Justice of India. So he had access to the Chief Justice of India by virtue of his law degree. And he was able to use that access, and also his juniors at NLS, who were also clerking for at the Supreme Court, to get him access to that room. Now, those sources don't exist. They have been destroyed because the Supreme Court wanted space for office. So those documents have all been destroyed. So now you can't use them. So effectively, he has unique access to. He had unique access to, which is also true of other people. Like, for example, but this is beyond legal history. But say if you're looking at the 3-volume biography of Jawaharlal Nehru that Sarvapalli Gopal wrote, Indira Gandhi gave him unique and unfettered access to all the papers of Jawaharlal Nehru, which are inaccessible to any researcher today. If you want access to the private papers of Jawaharlal Nehru after 1946, when he actually became a public figure, because he became effectively the prime minister of the country, you need the written permission of Sonia Gandhi. Otherwise, you can't access. Right. So basically, none of us can access them. Right? So that even A.G. Nurani, who was a leading constitutional law scholar who's passed away last year or the year before last, even he wrote about this. So even a person of his stature can't access it. So you can imagine how difficult it is to access. Politics of access is also very important in research. Just keep that in mind. I'm sure you all already experience it, nevertheless. So Rohit De, by doing that, and he's done that for multiple cases. So instead of doing the set of cases that Bhatia was doing, he's looking at a singular case and just going deep and deep and deep by a variety of sources, which he's able to access. He also goes deep in time. So this case comes from 1950s. He goes further back into the 19th century to look at archival sources, to look at how the issue of cow slaughter was dealt with in the Hindi belt, especially in the United Provinces in Bengal, which is where the present day Bihar was. So he uses a lot of that to, in some ways, deepen our understanding of cow slaughter as an issue and situate that judgment in its historical context. So his approach is completely different because he's not interested in legal reasoning and legal principle, because he's not trying to derive a doctrine. His book is trying to demonstrate that the very fact that ordinary Indians invoked their fundamental rights in the Supreme Court and challenged the authority of the state to pass a law, by effectively using the Constitution in this way, they were legitimizing the Constitution and making the Constitution become a real document and not just an elitist document. His latest book carries that argument forward, even in the making of the Constitution. That's not what he was doing there. So here again, what you see is that there's a difference in approach. Very different questions, therefore sources are very different, therefore your findings are very different. Now here, but I don't use a lot of qualitative research of the kind that in terms of interviews, I won't be able to speak much to that, but I will end with this. So there is another method which I referred to when I was talking about Granville Austin, which is called oral history. Oral history is very specific to the discipline of history. Oral history is different from doing, say, interviews for anthropology or sociology. Firstly, oral history does not allow anonymity. If you're using oral history as a method, you should not be anonymous. The interviewer, the narrator, interviewee should not be anonymous. Otherwise, it does not work in oral history. And oral history is effectively about trying to interview a person to remember what they do about an incident or a process or their experience in the past. And what it's trying to do is trying to almost recover an autobiography through the mode of a dialogue, through an interview, which is why it's important to also for people to identify themselves. And anonymity is not a thing in oral history. But if you were to do legal history, say of the sort that Granville Austin did, oral history is a very rich method to use. And oral history is also a method that legal historians do use when the actors are alive, when the persons who are relevant to a case are alive. And there, for instance, ethics becomes an issue, which is not otherwise generally an issue in legal history, because you're not really dealing with any person. You're only dealing with documents. So what you're actually dealing with more is the politics of access than ethical conundrums and ethical dilemmas that come. But they come in, for instance, like I gave you the example of the Babri Masjid judgment. If you were to look at that judgment historically, what is it that you would do? You would firstly go beyond the text of the 1045-page judgment. You will try to access the petitions filed by all sides. There were multiple parties there. There was what the Supreme Court called the Hindu side and the Muslim side. And there was even Ram Lalla, who was the actual party who won. Ram Lalla is the god Ram. The god Ram won the case. Okay, so thing to remember also. A god won that case. Okay, so that's this kind of story that's there. So you will look at all the petitions that are filed. Those are easily available because that case was such a high profile case. It's a very recent case. You'll find that. That will give you the judicial reasoning. That will give you arguments of all parties. But if you really wanted to get a sense of why the judgment came out the way it did, why was it anonymous? Why was it unanimous? Interviewing would be the most credible way of doing it because all the parties are alive. Now, you must have seen a lot of podcasts of the former Chief Justice of India, D.Y. Chandrachud, where he's been asked the question and he's always found a way to not answer the question. Because, of course, he'll not answer the question. But the thing about, and this is something that I've learned from my students and from my colleagues, is that judges don't always write the judgments. They look through the judgments, but the grunt work of researching and writing is done by their clerks. Clerks are these recent graduates of these top national law universities, such as the one that I'm teaching in. And these people go on to become clerks, and they are the ones who are doing the grunt work of the writing. So ideally, if you could get one of them or a bunch of them who were associated with the 5 justices to say what the actual reasons were to arrive at the reasoning, you will actually know why that happened. Otherwise, you will not. Otherwise, what you have is you are still functioning at the level of rhetoric. But there, of course, there's the ethical dilemma. They are bound by confidentiality. So that's a huge problem. And everyone's alive. I mean, if everyone dies and then it's okay. Like, for example, I'll give you related to the Babri Masjid case, K.K. Venugopal, who is the former Attorney General of India. He has recently published his autobiography. It's only when they publish autobiographies do they tell the actual things that were happening. For 30 years, he said nothing. So he was the advocate on record of the government of Uttar Pradesh when the Babri Masjid was demolished. And the government of Uttar Pradesh, through the Chief Minister of Uttar Pradesh, Kalyan Singh, had given an undertaking to the Supreme Court that the Babri Masjid will not be demolished. And he, as the head of the state and responsible for law and order, will protect it. And Venugopal writes there that Kalyan Singh completely lied to me. He completely lied to me. He knew what was going to happen. He did nothing. Right? So he's saying it now. He didn't say it in 1992. In 1992, he was presenting the version in court. He's in 2026. So 26 plus 8. 34 years after the event, he stopped. So that is what you would need the kind of access. Again, politics of access is there, but also some ethical conundrums is there because Kalyan Singh is the client and the government of Uttar Pradesh is the client. How do you break that lawyer-client confidentiality? You can't. So there's also those limitations. But now they're long dead, so it's fine. So there's like a thing that happens. Right? So those things are, of course, factors that take. And only then do you actually, so even for something like legal research, I would say that if you're doing some version of history, or even if you're doing qualitative research, to be able to actually interview principals who are involved, or their people around them who are involved, actually gives you far greater insight than any text can. Because the text is actually limited to the level of rhetoric or reason. It's not reality. There is rhetoric, there's reasoning, but that's not reality. Reality, for instance, could be, and this is where the contextual approach comes in handy. This judgment was decided in December 2019, 5 months after the Bharatiya Janata Party returned to power with an increased majority where they could effectively run the government on their own. Is there a causal link between the two? We don't know. Is there a contextual link between the two? Yes, there is. So that is what a historical approach, even in legal history, is supposed to do. It is supposed to excavate relevant context, even if you can't get access to, say, principals who can tell you the real story, to be able to tell a story about what is it that was happening in 2019 that this judgment finally comes. So with that, I will stop because it's already 45 minutes and I don't want to take more of your time. If you have any questions, if you have any specific questions about ideas that you are kicking around in your head, I'd be happy to answer them. Maybe that will also help me bring up some more points that I may have forgotten. But thank you so much for listening. I hope this was worth your time.
Thank you so much, Srijan. Now I would request all the participants that please, you may ask your questions, feel free to ask your questions. You may either ask them yourself or you may simply post them here. Alternatively, you can also send your questions personally to me or to Vidushi. So, yeah, please go ahead. Please feel free.
Meanwhile, before we have questions popping in the chat box or anyone asking, I'd just like to kickstart. Thank you so much, Srijan, for actually bringing this was so well articulated and so well explained, and for actually sharpening our focus so much and clarifying the basics from the very basics itself. So when you are talking about the contextual approach, and I don't work in with legal research in any way at all, but as a matter of curiosity, when one is building context, how far as a historian specifically do you decide to go? Like, how do you set a point of starting that this is how far my archival sources would go and tread and build into the context? And researchers often grapple with this in different disciplines, across disciplines. So any inputs on that?
So at least what I try to do is, which is not necessarily the best way of doing it, is that if, say, my starting point is, say, in my own research, it was the freedom of speech and expression. So I'm starting with the text of the Constitution. So I'm also in some ways following Austin's path by, from the text, I'm going to the debates. From the debates, I'm going to the minutes of meetings from any committee. And from there, I'm trying to go outside. So say one thing that I tried to do was that I tried to look for oral history interviews, and the Nehru Memorial Library, or now, sorry, the Prime Minister's Memorial Library, has a very rich repository of oral histories, which were done in the 1970s. They are not always, the original recordings don't exist, but the transcripts exist. So they are very helpful. For instance, the hero of my thesis, if one can use that word, was a person named Hukum Singh, who is a forgotten member of the Constituent Assembly, went on to become the Speaker of the Third Lok Sabha, was a survivor of the partition, and was one person who consistently opposed any restrictions on the freedom of speech and expression. So I began my thesis with him, I ended my thesis with him. And there is a 400-page oral history interview of his that's available in the Prime Minister's Memorial Library. So basically what I'm trying to do is then I'm trying to look at all the principles. How do I know about Hukum Singh? Because in the Constituent Assembly debates, he's one of the 7 or 8 people who've spoken out against the restrictions on the freedom of speech and expression in Article 19. So I've locked in on Hukum Singh. I want to now know more about this person. So I'm looking, had this person written an autobiography? He hasn't. But has this person, oh, this person's there in that oral history archive. So let me look at his stuff. Similarly, K.M. Munshi was a very important member of the Constituent Assembly. Now, K.M. Munshi, can I find an interview? Yes, I can find an interview. The interview doesn't have a lot happening there, but he has written a 2-volume autobiography. Okay, let me go to that autobiography. So effectively, because I'm starting there, I'm trying to go as far as my sources can allow me. In terms of the idea of free speech itself, I can go back to 1895 itself, because 1895 was the first attempt that was made in India to think about free speech in a constitutional sense. So one can go there. One can even go further, although I did not go further. One can go even further to say 1820s, when Ram Mohan Roy wrote a couple of letters or a couple of pieces against press restrictions that were placed by the early English East India Company. But I didn't go as far as back as that, because for me, because my starting point was the Constituent Assembly of India, I saw that the members were not necessarily referring to anything or were necessarily drawing on anything that felt like this is coming from Roy. If I felt that there was some hint that maybe this is also coming from an older tradition, then I would have gone back in time. Like, for example, there are some members who kept invoking the Dharmashastric tradition. If they are invoking the Dharmashastric tradition and that was relevant to my research, then I would probably go not to the Dharmashastras themselves, because the Dharmashastras are written in a time, and I am going to the colonial translation exercise of the Dharma Shastras, because that has probably some impact on how these people have found out about it. That is how they are also. So I have to get a sense of, when I'm encountering individuals in the archives who are relevant to the research at hand, what are the possible sources of their knowledge? There is a bit of guesswork that's happening. If there are some clues in something that they have said, I'm trying to trace back there, and that's where I'm stopping. But it is possible to go back further in time depending on who's doing the talking, who's doing what. Like if you were to look at the Babri Masjid case now, you can go back easily to 1850s. You would have to go back into the current dispute. Then you would, from there, you would have to go to say 1528 when the Babri Masjid was built. Then you would have to also go to say, sort of the Mughal context. Then you would have to go to also the Ram worship tradition. None of this will actually give you causal links, but they will create a context. And that context will tell you, for instance, that Ram worship tradition is a much more recent tradition than even the mosque itself. And you will also then discover other things about Ayodhya, the place, and so on and so forth. So I would say you start with your actual topic and then try to see the principles involved, then try to see how far back you can go, and then stop. Because otherwise it's just, there's no end to context, but you have to circumscribe context somewhere.
Sure. Thank you so much. Akanksha, there's a question in the chat box you could think of.
156.3 CRPC petitions, the archives of public archives. Okay, I would say that they are difficult. I would say they're near impossible to access. The reason why I said that is because if I give you the Rohit the example, the only way you can access is that you would have to go to the Supreme Court or you would have to go to the High Court. If there are 156 CRPC is Code of Criminal Procedure. So if there are, say, cases that are on section 156 and there are cases that have been filed and they have gone to the High Court, you can try going to the relevant High Court to see if they have a records room and they have records of the cases that you are interested in and whether those petitions are available for research or not. Chances are, from what I have heard and what I have seen, the answer is that you will not be able to find any. Because the Supreme Court and the High Courts don't maintain necessarily an archive. They don't have an archiving culture. And they don't also have a culture of sending their older documents to the National Archives or to a state archive. That does not happen. So National Archives and the state archives only get documents from government departments, tend to get documents mostly from government departments. And the judiciary, I guess, because they consider themselves independent from the government, don't submit anything there. So you are unlikely to find documents, to be fair, to be honest. So I won't give you any hopes in terms of that until unless it's a very famous case. It's not going to be there, is my impression and what I have seen.
Thank you, sir. Sir, what can be the sources to access case laws? Like we have Indian Qanun and etc.
Yeah.
These websites. So what are the authentic sources?
So Indian Qanun is a very good source. That's what I depended on for my research. Manupatra is the other source. Manupatra is a database like Indian Qanun. They are similar things. That Manupatra is something that one can access. Usually law universities have subscriptions to it. You can also buy a subscription. So Manupatra is the other useful source. So it's either between the two. What I would also say that if one can, so what say Manupatra and Indian Qanun do is that they digitize it, but it's not the actual text, the scanned text of the judgment. For that, what you would have to do is that once you have identified, say, the case number and the judges involved in the case. So Manupatra and Indian Qanun allow you to do free text searches like Google. So you can get a lot of potential cases. Then you identify what cases is relevant to you. So all cases have something called a head note. A head note is a brief, sometimes useless summary, but it gives you some sense. So you use the head note to get a sense of whether this case is relevant for me or not. Then you take the case number and then go to the relevant High Court's website or the Supreme Court's website. If you go to the relevant High Court's website and the Supreme Court's website, you can get a scanned copy of the physical judgment itself. It doesn't make a lot of difference, but I just prefer it even in terms of citation and annotation because it's page number wise. It also tells me things like they write too long judgments. You can actually compare length of judgments. From the 1950s to the present, the length of judgments have exponentially increased. One can actually do a study of that also, about how judicial reasoning functions. So for those things, I think it's helpful to have texts of judgments rather than having digitized judgment. So I would say do that, but you'd have to start with either Indian Kanun or Manupatra, then go to the relevant. You can now, there is something called ecourts.nic, which is also a database of lower court judgments. So one can even try that. They are not very easy to access because they don't, something about government digitization projects is that they forget that people have to access the documents. It's not enough to digitize the documents. So I have colleagues who have actually gotten their tech friends to scrape these websites to get all of the relevant things, which is you have to have access to such people who can write code and who can figure this out, and they can then scrape all these websites to get all of these things done. But nowadays, thanks to AI, it should be possible to do. I have never attempted it, so I won't promise that it works. But one can potentially do it, because otherwise, if you just do searches in these websites, they're very difficult to get you sources. Similarly, with say, if you're looking at Constituent Assembly debates, for Constituent Assembly debates, now there is a website called constitutionofindia.net, which is the result of a digitization project that the Center for Law and Policy Research in Bangalore, which is headed by a senior advocate named Jayana Kothari, who is married to Sudhir Krishnaswamy, who's the Vice Chancellor of National Law School of India University. They have done, it's an excellent resource. They have digitized most of the publicly available sources related to the Constitution of India. So that is the first place to go. That's where I send my students also. Nevertheless, if you want to see the actual published text of the proceedings, they are also available on parliament.nic.in. What they have done is that they have finally come to the 21st century as parliament, and now they've digitized all of it. And what they've interestingly digitized, and this is something that I had done my field archival research in 2013. I wanted to access a report of the Parliamentary Standing Committee, not Parliamentary Standing Committee, a joint parliamentary committee that was looking at the First Amendment to the Indian Constitution, copies of which were not available online or in an archive. You had to go to the Parliament Library. I couldn't get into the Parliament Library, even though I was a bona fide researcher, because they don't care. I was able to go to the Library of Congress and get access to American documents, CIA declassified documents, not relevant to my research. But in our own parliament, for a parliamentary standing committee report, I couldn't get access to. But now all of those standing committee, all legislation that goes to committee, all of those reports have also been digitized, which is a rich resource that was earlier not available. You could very easily access, say, parliamentary proceedings or, say, legislative proceedings, but you could not access these reports of committees. Now, all of them have also been digitized. So that's also great research, a great resource for any legal researchers or in people interested in research around the law, because you have more access to documents. The Parliament Library is still not very easy to access. So one can't put any hopes on that. So whatever's digitized is your best bet. Or if you're well connected, then that's a different book.
Thank you so much. So there's another question in response.
Should I use NGOs, lawyers, or activists?
Yeah.
Yes, you can. They are usually, if they are the ones who are the petitioners in the case, or they are the ones who have appeared for the case, the lawyers have appeared for the case, the NGOs have filed the petition, then they are the people to go to. And sometimes, like for example, if you are working with anything that Flavia Agnes has appeared for, Flavia Agnes is a well-known feminist lawyer. All of her files are available at NALSAR University. She donated it to the NALSAR University. We haven't neither have we digitized it nor have we accessed it, so archived it. So it would be near impossible to go through. But in principle, if you had that kind of time and energy, you could actually go through all of the boxes to figure out where the relevant file might be. So similarly, if you know the lawyers on record, then what you can do is that try to get in touch with them or the NGOs and see if they can share those things with you. So for example, a research scholar who's working with me, she's working on the queer community and their relationship with what is known as chosen families. And so what she's doing is that she's going to NGOs and trying to see what she can get from them and activists, because there is no other way that she can. There are no documents for the kind of research that she's doing. But she's doing a version of qualitative research, so it doesn't apply to historical research. But yeah, that would be the way forward.
Okay, I have got a direct question about responsibility and positionality as a researcher. So, how should researchers think about responsibility when interpreting legal cases that involve real people and real conflicts? And can positionality sometimes limit what we say about that?
My short answer would be it doesn't actually affect, because unlike, say, anthropology or sociology, which are far more ethically fraught disciplines because of the kind of sources that you've accessed. If you're working with, say, law sources, those are almost always publicly available sources. And if you're unable to access them, it is because things that should be publicly available are not publicly available. It is not a problem that you are accessing something private, and therefore it becomes a fraught ethical issue. So because it's in the public domain, that is not an issue. But yes, positionality does matter in terms of, say, the example that I gave you of my research scholar who's working on the queer community. Now, I would hesitate to work on the queer community because A, I don't share the lived experience, and I don't think I have enough insight or enough know-how to be able to do this in a way that is not ethically compromised. For similar reasons, I also hesitate to work on, say, caste, if one is looking at, say, how the SCST atrocities cases are actually dealt with in courts. Anyone can work on it. Of course, these are also public records. I would hesitate to work on it because I am not from a marginalized community. So therefore, I just find it, I have not been able to justify that in my head. It's not that you can't, people do. For example, one of the greatest living scholars of caste is Satish Deshpande. Satish Deshpande is a sociologist. Satish Deshpande sort of gets around it by focusing on the dominant caste and what happens to dominant caste. So that's also an ethical position he's taking. He's not necessarily focused on, from at least what I understand. And again, I'm not really familiar with his work, but I'm seeing. Similarly, Ajanta Subramaniam, who's written The Caste of Merit. Ajanta Subramaniam, not from a marginal caste, but she's also not looking at, she's looking at how the dominant caste folks in IIT Madras justify their merit and think about their merit, right? So those are the kinds of positions that one has to take. The sources themselves don't, I think, create an ethical issue, at least in my mind, they don't. But in terms of position, what sort of research that you choose, I at least have those things. I picked freedom of speech and expression because that's a citizen's right. It affects different groups differently, that's true. But it's a citizen's right. So we are all citizens. And as a citizen, then I feel like, yeah, I have skin in the game. So I feel more comfortable researching those things, at least, but that's my personal position.
Thank you so much. That brings me to this idea of interdisciplinarity, and you also mentioned that while you're coming from a background of history, so that has an impact over the research, right? Can there be a purely legal research without an impact of, say, history or political science or sociology?
Not in primary sources, it might be, say, if you take a doctrinal approach, you can do research without any reference to any other discipline. But even within the field of law, that's not necessarily encouraged. Even here, for example, in NALSAR or in other national law universities where people are working with the law, they are encouraged, sometimes required, to also look at scholarship that is produced on their interested subjects in other fields. So for instance, there's something called critical legal studies. Critical legal studies is an intellectual movement that developed in the field of law, which spoke of the law as not this neutral body at all, but a very compromised body created by context. So therefore, to be attuned to context, aware of context, understand the politics of lawmaking, politics of judicial reasoning, understanding that requires you to go beyond the text and look at other sources, other methods, other disciplines for their scholarship to get insight. So from what I have seen, at least over the last few years when I've been interacting more closely with scholars in the field of law, most researchers now do look at scholarship from other disciplines to enrich the study of law. And similarly, there is also something that we can, those of us who are not from the law, learn from what they are doing in terms of trying to identify reasoning and doctrines and all. And even that can be interesting. Even say a history of doctrines can be interesting. A history of textbooks. So, for instance, law is taught to students through textbooks. Textbooks try to consolidate case law into something akin to a doctrine, which is what is taught to students. The law textbooks have been produced in the Indian context since the 1860s. And there are legal scholars and legal historians who have looked at the production of textbooks itself, try to get a sense of what are the traditions they are drawing from. Because in the 1860s and 70s, there was no real case law in India. So everyone was drawing on anything from the West. But now, of course, things have changed. So one can do that. Like an incredible article that I would highly recommend to people is that there's a criminal law scholar named Mrinal Satish who teaches at National Law School of India University. He co-wrote an article with Durba Mitra. Durba Mitra is, she teaches gender and history at Harvard. They worked on how medical textbooks impact rape jurisprudence. It's an incredible article. It was published in the EPW, which I read when I was a research scholar. I've never forgotten that. Because what they have found is that very outdated ideas about medicine and about the female body that come from the 1860s and 70s, and those textbooks have been reproduced in newer textbooks. And those are actually used by judges in their judgments. You will see in the judgments, they will say, this textbook says this, therefore we are doing this. So textbooks are not innocent. They are not just a repository of knowledge. They are not even knowledge in many cases. So they have done that. So that's an incredible example of how Durba Mitra's historical training and Mrinal Satish's legal training have been brought together in a way that's not just interesting in terms of scholarship, but has actual consequences on jurisprudence itself. Whether or not judges use it is a different matter. So that's published in the EPW, Economic and Political Weekly. So that would be a great, I have, at least of all work, I have seen incredible example of interdisciplinary research.
Thank you so much. And there's one more thing. So you mentioned in between that courts do bring in aspects which are otherwise not required, right? And then they use that as a base for further judgment.
Yes.
So while we consider these laws and everything as very empirical substantive sphere, but do you think there's a like politics of symbolism involved in it? So like just throw some light if you can.
Yes, there is a lot. So for the best way to discover this is to look at judgments that emerge from section 498A of the Indian 498A is domestic violence and also domestic violence act. And what happens with, if you don't even have to do any research for it. Just go to a website like Bar and Bench. Bar and Bench usually reports a lot of judgments that are produced by high courts and Supreme Court. Bar and Bench are live law. And I guarantee you, almost every week, there is one judge or another lamenting the misuse of these provisions. Always. It is, you can see this pattern. And because I now look at a lot of judgments, my Google suggestions are also about Bar and Bench and live law. So you can also make the algorithm help you. And what happens is that you can see this kind of lamentation of abuse of these these provisions by women. Now, this coincides with the men's rights movement in India. So you can see a parallel between the men's rights movement that is happening in India outside the judicial sphere and judges who seem to be parroting those same points. The reason why I say this is because if one is looking at abuse of law or misuse of law, one very rarely hears such pronouncements about the UAPA, the Unlawful Activities Prevention Act, which is also abused. One very rarely sees this about PMLA, which is the Protection of Money Laundering Act, no, Prevention of Money Laundering Act, which is under which all opposition politicians are always put into prison, right? So you will rarely see, and these conviction rates in these cases are minuscule, but you will rarely see judges pronounce on a regular basis how these laws have been misused, and they are misused by the government. Here, all laws can be misused. That's the nature of the law. And there are provisions in the law, and that is why the judicial process exists, for you to identify the misuse and then give justice. But you will see a very different tone being used for this, and very different tone being used for laws that are misused by the state. So that tells you something about the politics of lawmaking, or politics of judgments and judicial reasoning also. So I think that is a key. And you do this with, again, things like, another thing that you see is cruelty, the term cruelty, and what judges consider cruelty and what they don't. And there is, I have not come across this research, but there is research to be done by just taking the term cruelty, which is a legal term, and see how it's applied through a case, which is basically the doctrinal method. But if you were to do the doctrinal method and then contextualize it with what's happening outside, say whether it's the men's rights movement, whether it's the incels, whether it's the manosphere that, say, Louis Theroux has now done a recent documentary on, all of that, if you look at that, then you can contextualize this sort of judicial pronouncements also, and see that there is, if not a causal link, a contextual link between a widespread misogyny that is encouraged or tolerated in society, and judicial reasoning that seems to find legal ways of rationalizing that. That would be an example, I think.
Thank you so much, Dr. Srijan. Are there any other questions? Please feel free to ask. You may either ask those questions directly, or you may just post in the chat box. Otherwise, we can just wrap up. All right. So thank you everyone for being here. And thank you so much, Dr. Srijan, for giving us time, for making us know so many new things. And for the participants, thank you for being here.